Okay, welcome back to Law and Crime Network. My name is Bob Bianchi. I'll be taking it for the next 2 hours. Our trial coverage takes us to Broward County, Florida, for the trial of Jamel Demons, better known by his stage name YNW Melly. The South Florida rapper is charged with 2 counts of first-degree murder for the deaths of his 2 friends, Christopher Thomas Jr. and Anthony Williams, who are also part of the YNW collaborative, along with Cortland Henry. The co-defendant in this case will be tried separately, those cases having been severed. Today, court is off to a late start because of a juror issue, and we're going to recap some of the key moments from Thursday's testimony due to the court being dark on Friday and Monday. And as soon as court starts, of course, you know we're going to jump right into it. So let's listen to the testimony of forensic scientist Tara Shell.
And without getting into the actual results, we're just going to orient the jury to the chart that I have here, beginning with the top left.
Yes, so the top left is an image kind of showing where the particle is located on the sample, and that is taken at 400 times magnification.
And the top right?
That is now a closer up image of that particle taken at 3200 times magnification, where you can see clearly that it is bright, it is round in shape, and you kind of are able to visualize really the morphology of that particle.
And bottom left?
So that is what is called the EDS spectrum. Basically, it's just showing you what elements are present in that particle. So PB is lead, BA is barium, and SB is antimony. So you see peaks for all of those present in that particle. Therefore, it is a particle that contains lead, barium, and antimony, which makes it characteristic of gunshot residue.
And are the peaks that we see consistent with the amount of that compound within the sample?
Yes, overall, the height of the peaks relates to how much of that element is in the particle.
And finally, the bottom right.
So that is the image that the instrument takes during the automated analysis.
I'm showing you what's been entered into evidence in states 57. Do you recognize that?
I do, yes.
And what is that?
This is a gunshot residue kit that we received in this case.
Okay. And did you analyze states 57?
Yes, I did.
And did you ultimately analyze state 60?
Yes, I did.
Okay. So, grab your scissors. Go ahead and open states 57. And I'm going to ask permission from the judge for you to step down.
Okay.
You may.
You want to open it, grab some gloves, and we'll
Okay.
go to the machine.
Just if you can publish states 57.
And the contents. So you received one sample, but there are 2 tubes.
Yes.
What are they representative of?
These were samples that we had received that are labeled as coming from the right hand and the left hand.
And who's the individual?
Cortland Henry.
Did you ultimately have a chance to analyze and go through this SEM process, which was the automated process, and your individual process, in order to come up with an opinion as to the presence of GSR?
Yes.
And what was that opinion? And if you can specify both the left and then the right.
Mm-hmm. So the right hand of Cortland Henry contained 0 particles characteristic of gunshot residue and 2 two-component particles. And the left hand contained 1 particle characteristic of gunshot residue and 1 two-component particle.
Okay. And can you explain to us what that means?
Basically, overall, there was gunshot residue present on the hands.
Okay, and what affects the presence or absence of GSR on a person's hand or any object?
Sure. So If there is gunshot residue on someone's hands, that means that the individual got it on themselves by either discharging a firearm, being in the proximity of a firearm when it was discharged, or by coming into contact with a surface or object with gunshot residue on it.
Okay. And if we may go back to the demonstrative aid, what was this demonstrative aid? Was this representative of your results of Cortland Henry?
Yes, that was the particle characteristic of gunshot residue that was on the left hand.
And the components, which you explained before, there are three kinds or three compounds that you were looking for, and which compounds were present in Cortland Henry's left hand?
Lead, barium, and antimony were present in that particle.
So all three components.
Yes.
Okay, and let's move on to stage 60, which was the sample for the Jeep. What were your results? And again, did you also go through the SEM automated process and then your individual characteristic process?
I did, yes. So there were 0 particles characteristic of gunshot residue, but at least 9 2-component particles.
Okay, and what does that mean?
So, like I mentioned, 2-component particles can come from gunshot residue, but they also have other sources. So, because of that, these results are basically inconclusive. They could be gunshot residue, but they also could be from something else, and I can't say which it is.
Okay. In your analysis and reviewing the sample, did you find anything inconsistent with gunshot residue, if I'm phrasing that correctly?
Correct, and I did not. So overall, with 2-component particles, or any of the particles we look at, oftentimes if the particles are from another source, there are other elements or amounts of elements that would be unusual to find in gunshot residue. So, for example, one common source of 2-component particles is brake pads. Brake pads typically contain high amounts of the element iron. So if I'm doing my analysis and I come across particles with high amounts of iron, I eliminate them and I do not report them because there's something about them that would suggest they're from something else. So while I still cannot call these particles gunshot residue, there was nothing about those particles that were unusual.
Are you familiar with them in general?
I am, yes.
Are you familiar with the friend or foe presumptive GSR kit?
I am.
What is that kit testing?
That kit is like you said, a presumptive test that is looking for the presence of nitrates, so nitrogen containing compounds.
Okay. So for instance, these GSR kits are made to essentially alert to the presence of a certain compound.
Yes.
And the friend or foe kit specifically alerts to the compound of nitrogen particles.
Yes.
So the presence or absence of nitrogen particles.
Correct.
And are presumptive tests relied on exclusively?
No, they are just a screening tool. Like I mentioned, they're looking for nitrates, and there are many things that can contain nitrates. So they are not conclusive to the presence of gunshot residue or gunpowder. They are really just to be used as a screening tool.
Okay, well, welcome back. I still have Brian Buckmeyer in studio with me. You know, what can I say? He's just everything extraordinaire at the Law and Crime Network. So it's great to have my friend here, as well as Natalie Whittingham-Burrell, who is a criminal defense lawyer. And I'm being told, I'm looking at the producer says here, known as, this is what I'm being told you're known as. This is not what I am saying. Let's be clear for the record here, that you are referred to as the lawyer chick on YouTube. Is that right? Is that what you refer to yourself as?
Yes, so I will not be offended. Here on YouTube, I am known as Natalie Lawyer Chick.
Yeah, I don't want to step into anything here, but anyway, that's great for you because I hear that you're awesome, and I'm glad that you're here on the show. Natalie, let's look. This testimony as a prosecutor, still to this day, all these years later, makes me want to faint. I get nervous. You have to put it in. It's important to the case. You don't want to lose the jury. So rather than talk about the ins and outs of the perfunctory part of admitting your evidence in, which is a skill set you have to learn as a prosecutor, what are your thoughts about the trial overall, where it's going? What are you seeing?
Well, from the perspective of a defense attorney, I know that jurors treat forensic evidence very, very seriously, and the presence or lack of it can be detrimental to a prosecutor's case. That does not mean that a state cannot win their case without that forensic evidence. And here, they just don't have the forensic evidence to back up their case. What they have is YNW Melly in the back seat, even according to his girlfriend's mother, and phone records placing him there when the shooting is alleged to have occurred. That's their best evidence. But this gunshot residue being found on YNW Bortland's hands is more helpful to YNW Melly than it isn't. The same thing with the ballistics evidence. It was more helpful to YNW Melly than it was not helpful to him.
Wow, a great point, Brian. We were talking with Ann Jeanette before, and I want to get into this because I think it's so important. They're talking about the motive, and I hate when, and it's true, the prosecution does not have to prove motive, but you sure want it as a prosecutor, and a defense attorney is sure going to say, what would cause him to do this? Now, we're talking about aggravating factors, Brian. We talked about it before, and I heard that there's a dispute. It could be, maybe it was over a financial thing, assuming you want to believe the state's theory of the case. Maybe it's gang related. First of all, where, Brian, is the evidence of the gang related aspect of it? Is just another wild throw it out there? Because this is really important, because the gang relation is one of the aggravating factors for the death penalty case, Brian.
Yeah, so first and foremost, understand when I answer these questions what I am. I'm a former public defender from Brooklyn, not from Brooklyn, but practice in Brooklyn. And so what I see oftentimes in cases like this, unless you're going to get that smoking gun of my client's in a gang and watch him do gang stuff and look at this video of him acknowledging that he's in a gang, they're just going to throw circumstance and the typical tropes. Look at his face. He has tattoos. Look at the way he raps. Look at the way he holds himself. Clearly he must be in a gang. But there's no, unlike what my grandfather, my mom probably says, guilt by association. You have to actually participate in the gang. You can't just go on a social media or go on a rap video and say, hey, I'm a part of this crew, or hey, I'm a part of this crew. Hey, you can even be part of that crew, but if you're not doing anything gang related, the enhancement doesn't seem to work there. And here we have a case where no one's quite sure what it is. Is it money motivated? Is it gang motivated? Maybe he is in a gang, but this was his day off. I don't know. But I don't know, I guess they get days off. We get days off as attorneys. I assume you get days off on gangs. You can't be gang banging every day. But if there's no evidence and there's just this pomp and circumstance of, look at his face, look at his tattoos, he says he is a gang, this must be gang related because someone died around him, I don't see the aggravating circumstances.
Yeah, and Natalie, I go to the point, and I think that this is not a liberal concept. This is from a person who's tried death penalty cases as a prosecutor. I want to be absolutely convinced who the shooter is in a case like this, and I want to be absolutely convinced as to what the motive is, because with all respect to the judges and the defense lawyers and the prosecutors, the system is not infallible, and I think in the end as a prosecutor, tactically, the defense is going to jam this down the prosecutor's throat in summation to say they're just throwing the spaghetti against the wall and hoping something sticks, and then they ask you to convict him of capital murder for that? I mean, you talk to me. What are your thoughts as a defense lawyer? Because this is one where I think they can really get outraged about.
Yeah, as a defense lawyer, I always anticipate where the state doesn't have a motive. And I know that in closing, the state's going to hammer home that they don't even have to prove a motive in order to prove their case. But we know juries and we know real life people, and they're going to want to know why. Why did this happen? And so far, there's been no evidence of a why. If you believe that YNW Melly is in a gang, then you must also believe that YNW Sack Chaser and the other gentlemen were also in the same gang. What type of conflict was there in order for this alleged murder or hit to be ordered or carried out by YNW Melly? There's just no evidence of it so far. And as you said, in a death penalty case, the jury's really going to want to see the proof.
Yeah, and I'll tell you what, it's not just so much showing what the motive is, i.e. if they want to prove it's gangs, it's just show it's not any other motive. At least that's what I would do as a prosecutor. Anyway, now let's take a listen to the cross-examination and a bit of the redirect.
You got the sample from Marijuana Police Department?
Yes.
Specifically, Detective Moretti directed it to you?
Yes.
And when we talk about GSR, or gunshot residue. You're aware that GSR can be found on clothes, correct?
Yes, that's possible.
Did Detective Moretti send you any clothes of Cortland Henry?
He did not.
He didn't send you any of the clothes?
No.
Did you know that the clothes of Cortland Henry were collected by the Miramar Police Department?
Objection calls for speculation outside the scope of the court.
Well, I don't know that it calls for speculation. If she knows, she can answer the question. Overruled.
Were you aware that the Miramar Police Department collected Cortland Henry's clothes?
No, I was not aware of that.
In your examination, had you received clothes, you could test those clothes for GSR, correct?
Yes, we can
And you-
certainly test clothing.
And you've done that many times, correct?
Yes, absolutely.
Also, if someone is in a hospital, in a bed in a hospital, do you know if that person has washed their hands?
I don't.
Okay. And by washing your hands, you can get rid of GSR, correct?
Yes, hand washing can remove most, if not all, of the particles on someone's hands.
Do you know if Cortland Henry washed his hands or changed his clothes?
I don't know that.
Is hand washing the only thing, contrary to popular belief, that removes gunshot residue?
No, gunshot residue is easily removed in general. So with respect to the hands, any type of activity, touching or use of the hands can remove particles pretty easily. With clothing, any activity. So if the garment is touching things, if it's laundered.
If it's removed.
Yes, any activity can cause particles to be disrupted or removed.
And you're an independent lab, correct?
Yes, we are.
You're not associated with Miramar Police Department.
Correct, we are not.
You're not associated with the Broward Sheriff's Office.
We are not.
So you can only test what you're submitted, correct?
Correct.
Nothing further.
One question. If I may. You were hired by the Miramar Police Department to perform this test then, correct?
Yes, they're the ones that submitted the samples.
You can only test what was submitted. On that note, we're going to take a break. We'll talk about it on the other end. Please stay with us. Turns out to be why, and we're completely thrown off in the beginning of the case. But I have a moral responsibility when I get in there that I know, no matter how hard the evidence is, that this is the person who did it, and we have done everything to check to see if it was anyone else and to build up that case so that all threads were tied up, if for no other
openings here in the forensic evidence. There were even openings with their civilian witness, the mother of the girlfriend. There were openings all over the place, and YNW Melly's attorneys are highly skilled, and so they got right into those openings and pointed out all of the inconsistencies, all of the ways in which the evidence is missing and lacking. And that was only cross-examination. Wait until they get to closing arguments and they're able to point out every single opening that was left by the state. All of those openings are reasonable doubt. At least that will be the defense's argument. Does that get them over the finish lines to not guilty or a hung verdict? I don't know, but I do know that it seems like the prosecution left a lot to be desired here so far.
Well, you definitely know things. My producer said you were rather prescient, and in fact, during the course of your answer, you proved that because Felicia Holmes, the mother of the defendant's ex-girlfriend, which you just mentioned, took the stand on Thursday, and there was never a dull moment for sure. Let's take a listen as to why.
Good morning, Ms. Holmes.
Good morning.
How are you today?
Not good.
Are you cold?
No, I'm just, I don't feel comfortable.
Are you nervous?
I feel threatened.
So, Ms. Holmes, I want to start and just talk about who you are.
Yes.
Ms. Holmes, do you have any children?
Yes, I do.
Can you tell the ladies and gentlemen of the jury who is Mariah Hamilton?
My youngest daughter.
And how old is Mariah?
She's 22 right now.
And Mariah, did she have a romantic relationship with someone named Jamel Demons, also known as YNW Melly?
Yes, she did.
When was she involved in that romantic relationship with Melly?
I think it may be about 2016 or so till maybe 2019, 20.
Okay. Did you have the opportunity to meet Mr. Demons?
Yes, I did.
What did you refer to him as?
I call him Jamel Melly.
Do you see him here in the courtroom?
Yes, I do.
Where is he?
He's right here.
And what's he wearing?
A white turtleneck and a gray jacket.
Here, may the record reflect an in-court identification of the defendant.
Yes, the record will reflect the in-court identification of the defendant.
So I want to go back to October 26th of 2018. Where were you living?
I was living in Cocoa.
And my geography is terrible, I think. How far away is Cocoa from Broward County?
About 3-4 hours.
What do you do for a living?
I'm a registered nurse.
Were you a registered nurse at that time as well?
Yes, I was.
Did you know the defendant's mother?
Yes, I do.
And who is she?
Jamie.
Had you met her prior to October 26th of 2018?
Yes, I did.
Have you communicated with her?
Yes, I did.
Did you have a phone number for her?
I'm pretty sure I probably did.
I'm not asking you, sir.
I don't know if I did or not. I can't remember.
Okay. So I want to go forward on October 26th of 2018 and talk about that early morning hours. Did you receive or hear a phone call or FaceTime video call in which the defendant was a participant?
I did overhear. I'm not quite sure exactly the context of the call, but I did overhear the phone call.
Tell the ladies and gentlemen of the jury what woke you up that morning.
Just hearing my daughter's voice.
Okay. What was the tone of her voice without saying what she said?
I don't remember. I don't remember.
Okay. Do you remember anything the defendant said on that video?
Not verbatim, no, I don't.
Okay. Did you have an opportunity to read the statement you gave in 2018?
I read the statement.
Okay.
I don't recall. I don't remember anything from that statement, but I do remember my deposition from December 22.
So the deposition, that would have been 6 months ago?
Yes.
Okay. I want to go, and when you spoke, remember speaking with law enforcement in December of 2018?
I remember speaking with them, but I don't remember what they look like. I don't remember their names, but I do remember talking to someone.
Okay. So, Ms. Holmes, I want to ask you, were you honest and truthful with law enforcement when you spoke with them?
I would hope so. I mean, it was 2018. I went through a lot during that year, so I'm not sure where my mindset was at that time.
Did you lie to law enforcement?
I would hope not. But I don't remember what I said at that. It was like 5 years ago.
Oh, of course. I understand it's been a long time. So, in terms of time frame that was closer in time to the incident of October 26th of 2018?
If that's where you guys are saying it is.
You don't even remember?
I don't remember. Like I said, 2018 was a very hard year for me. My husband just went to prison. My father died. I had a lot going on, so
Of course.
I was really out of it.
Okay. And in terms of your conversations with the police officers that morning?
Yes. I do remember that they kind of bullied me and threatened my daughter to take her to jail for accessory after the fact. I do remember that.
Yes. And in terms of the statements that you made about what happened,
Yeah.
you don't have any recollection of that? Did you read this statement multiple times?
I looked at it and I just didn't recall it, and I don't remember.
And so you indicated you hoped you were truthful with law enforcement?
Yes, I did.
I have to ask you to be more definitive. Were you truthful?
I don't remember what I said to them back then, so if I was to tell you something now, I could be lying. I don't want to lie to stand because you're going to take me to jail. So I'm saying what you want me to say.
I do not want you to say anything. I want you to tell the truth.
Okay, that's what I'm doing.
Okay. So, Ms. Holmes, with regards to that day, did you lie to law enforcement?
I just answered that earlier.
Excuse me, overruled.
Ms. Holmes, did you ever say the defendant made you quit your job?
I never really said anything like that. I know what's ever made me quit my job.
Objection.
Overruled.
If I may approach him? I'm going to show you this next few minutes. So, Ms. Holmes, I'm going to ask you again. Have you ever made a statement that the defendant made you quit your job and that they would take care of us until the trial was over?
I never really say anything like that.
Okay. So you're denying making that statement?
I never really say anything like that.
Okay.
Objection.
Your Honor, can I just have a standing objection so we don't keep interrupting?
Thank you. Any statements we heard on the standing objection?
Whatever defense it
That's
chooses
fine.
to
Go
proceed.
ahead.
Okay. So, Ms. Holmes, in terms of the, have you ever said a statement, have you ever made a statement to the effect of, you were told to quit your job and the defense would take care of us?
Of the judge? No.
Excuse me.
The defense? No.
How much comes out?
Let me let Ms. Holmes, I can ask you, did your daughter tell you, did you have a conversation with your daughter about what happened on October 26th of 2018?
Yes, I asked her if she knew anything about that.
Did she tell you what happened? Without, no, she did
Just
not.
told she didn't know.
Have you ever made a statement that is different than that?
Your Honor, we'd object to lack of foundation, calls for hearsay, speculation, unless they can establish that that witness was present.
Thank you. The objection noted. That's what I previously ruled on sidebar. Proceed.
When you first took the stand, you said, "I feel threatened."
Yes, sir, I do.
Who do you feel threatened by?
Objection, Your Honor.
Overruled.
Christine Bradley, the prosecutor's office.
This prosecutor.
Yes, I do.
Thank you.
Well, I don't know who's more angry, the witness or the defense attorney on that one, but we're going to talk about it with our awesome guests on the other end. Take a break. Please stay with us.
We did get an update from the juror who was in the hospital this morning, and my understanding is she will be joining us. Everything was just, I guess, issue of dehydration or something along those lines, but I'm told she will be here. You hear me all right? All right. One thing, though, I need to bring to your attention is when we broke this morning, one of our jurors, as Gary was escorting the jurors out, he was approached, and one of the jurors had asked him a question. Gary, go ahead. You want to tell us exactly what was said?
She more or less asked me if she could ask me a question. I said, well, it depends. So the question was, she said, well, what's the status of the mistrial?
So now, I don't know what you want me to do about that, but that's the question that was posed.
Judge, we need to have her name on the record and find out how she would have any knowledge of that, because that was never stated in front of them.
I think it was. I think there was it was done on the record by Mr. Howard the other day. Is Mr. Howard here? No?
No, he's not.
Oh, I apologize. I thought we were all here.
He's coming right now, Judge.
Mr. Howard, I'm sorry.
Oh, no problem. I heard it all inside the media room. So no apology necessary. Thank you. Apologize for not being present, sir.
No, it's
Can't
my
see
fault.
me.
I thought Gary walked in, but what he was advising me and I to the attorneys was that there was a comment by one of the jurors. Did you hear that?
Yes.
So I don't know exactly what you want me to do. Who the juror was?
That was Miss Manuel.
Miss Manuel. So I guess one of the things that is, my recollection, and I could be wrong, is different than yours, Ms. Bradley. My recollection is that there was a motion for mistrial that was made out loud, and then Mr. Howard came sidebar. But the juror's been instructed not to read anything about the case. So I don't know if there's something in the newspaper about that. That's a different story, but I don't know what you want me to do, if anything. I bring it to your attention, any real interaction that Gary has with them, something that may seem inappropriate, we always bring it up and let you know.
And should I assume that for future reference, you'd rather I make those motions outside the presence of the jury?
Just come side.
Okay.
But that was my recollection. I thought you, at one point, I don't know which, there was two motions for mistrial. I don't know at which point, but I believe at least one point you stood up and said, I have a motion for mistrial.
No, actually, there was a question asked. I said objection, move for mistrial, and
No,
he called the
court.
sidebar and asked me to hold it until the end. And then at the end, after the jury left, Mr. Adelstein and I articulated motions for mistrial on an independent basis. And that's how it trended. That's how it went down.
But it was announced in open court, correct?
I said objection, move for mistrial. You called
That's
the
my
sidebar.
recollection.
I remember coming sidebar and there being that being said in sidebar. I don't recall it being said in open court.
I thought it was said in open court.
It's a fact that I said it.
So again, I don't know what you want me to do, if anything, and the jurors. Is that juror here, by the way?
She's in the reception area.
So anyway, I'll leave it to your discretion. It was announced in open court. There was a motion for mistrial. Gary obviously didn't answer the question. And, what did you respond, Gary?
I told her I didn't know anything about that. And then she asked me, weren't you there? I said, I don't remember that.
Anyway, that's where we're at. So you think it over. Let me know if there's any inquiry you want me to make. Madam?
Yeah, I think you need to, the state's position would be that she needs to be brought in. Your Honor needs to inquire if she's saying anything in the media or any coverage of that, because that was discussed online, is my understanding.
What do you think, counsel?
Well, to the extent that the court's inquiry of this jury is because of the state's faulty recollection that I didn't say move for mistrial in front of the jury, I know that not to be the case. I did say objection, move for mistrial. You then called a sidebar, and the only thing you said was, please reserve that to me.
That's my recollection.
Yeah, that's what
Again, is that what you're concerned about, or is it concerned about just because it was said that you think I ought to inquire?
Your Honor, I think that it's at defense's peril if we go forward and if they're going to waive any inquiry of this witness, if she's been looking at any of the other items or anything online that defense brought to Your Honor's attention earlier. Because if they thought was laboring under the impression that there was some sort of cessation of trial and then started looking at media and news reports because they thought their jury service was over, that would be a problem.
Better to have more information than less, so we have no objection to that being the procedure that we employ.
So you want me to bring her in, indicate to her that I was advised by our bailiff, Gary, that you had asked him about a motion for mistrial and what had happened, and just ask her, how is it that you're concerned about that, or where did you hear about it, and just find out what information she's got and about it and where she heard it from. Is that the end of the inquiry?
I would ask that you inquire from her if she conveyed any of that to any of the other jurors.
Anything else?
Unless the court wants to say, unfortunately, I denied that.
So we're going to ask what she heard, where she learned it from.
If she did any outside research afterwards.
And if she inquired or asked any of the other jurors concerning that topic.
Anything else that you want me to ask, counsel?
Anything else, David?
Nothing, sir.
All right. Do me a favor.
He went to get him.
Okay. I don't like it either.
Just for him. Gary. Yeah.
It's just pretty quick. Thank you. Thank you. Ms. Manuel's coming in, counsel. Ms. Manuel's going to come in now.
Okay. Thank you.
Yours, Zachary?
Hey, Ms. Manuel, thanks for coming back in. Let the record reflect the approach of the defendant, his counsel, the assistant state attorneys, as well as one of our jurors, Ms. Manuel. Counsel, please be seated. Ms. Manuel, please be seated. Ms. Manuel, why I brought in is my bailiff indicated to me that when you weren't able to start this morning, that he was escorting the jurors out, and you approached him and asked him about what happened with the mistrial or something to this effect. Is that right? So that's a yes. All right. So I guess my concern is what you may have heard about this alleged mistrial and where you heard it from.
The last day I was here, and the defense attorney jumped up and said mistrial.
Okay. So that's where you heard it from?
Yes.
Anything other than that?
No.
All right. Was there any other research that you may have done or looked at newspapers or any kind of article about the motion for mistrial, anything like that?
No.
Anything on the news, any news media
No.
about the mistrial? No. And last but not least, did you speak with any of the other jurors about the motion for mistrial?
No, when Gary came in and asked us this morning, did we have any issues, any questions? And I didn't want to ask him in front of everybody, so I waited till we got in the hall and I put him to the side and asked him that. If he asked me, he have any concern.
Okay. All right. Okay, that's what we're trying to clear up and find out. Because there's an admonition that I say every time we break, don't discuss the case, don't form any opinion about
No,
the
it was
case.
said in here.
That's what we're trying to find out.
Okay.
Thank you, ma'am. Appreciate it. Thank you. Let the record reflect the juror stepped out. Counsel remain will defend. Anything you wish to do regarding this issue with Ms. Manuel, counsel?
No, sir.
So are we otherwise ready to proceed?
The juror shows up, yes.
I think, are they all here?
As far as I know.
Okay, so see if they're all here. If they're all here, we'll start. Yeah, he did say we're short 2 or 3. 3. But they're here now? They're all here. All right, they're all here now.
This part.
You all ready?
Yo.
Okay, counsel, I'll bring you in. Is that all right?
Yes, sir.
All right, let's put the jury in. Thanks, Tom.
I did.
Jury entering.
Please be seated. Let the record once again reflect the presence of the defendant, his counsel, the assistant state attorneys, and as well as the ladies and gentlemen of the jury. Ladies and gentlemen, sorry for the late start. Hopefully everybody's all right. We appreciate your patience. We also appreciate the fact that you're all here, and we thank you. but we were ready to begin again. When we left off last week, the state was still on its case in chief. Madam, who's your next witness?
Susan Johnson of T-Mobile.
Susan Johnson, please. Good afternoon. Are you Susan Johnson?
Yes, sir.
Welcome.
Thank you.
What I'd like to do is raise your right hand for us.
Do you solemnly swear or affirm the testimony you shall give in this case shall be the truth, the whole truth, and nothing but the truth?
I do.
Please state your full legal name for the record.
Susan Johnson,
Please spell your first and last name for the court reporter.
SUSAN-JOHN-SON.
Please have a seat.
Thank you.
Ms. Johnson, that microphone in front of you will adjust up or down, but not back and forth. Okay?
Thank you.
Are you ready to proceed, ma'am?
Yes, sir.
Counsel, you may.
Thank you. Good afternoon, Ms. Johnson. How are you today?
Good, thank you.
Could you please introduce yourself to the ladies and gentlemen of the jury and tell them where you work?
Sure. My name is Susan Johnson, and I work for T-Mobile.
How long have you worked for T-Mobile?
A total of 26 years.
And what do you do for T-Mobile?
I am a manager within the emergency response unit.
Prior to working for T-Mobile, did you work for any other telecommunications companies?
Yes, I did.
And what were those?
AT&T Wireless.
And how long did you work for AT&T?
5 years.
How long in total have you worked in the telecommunications industry?
31 years.
So you indicated you were part of the manager of the emergency response.
Legal emergency response.
And what does that mean?
That means that we respond to subpoenas and other legal demands from various agencies across the United States.
And when you say a legal demand, what would you mean by that?
Subpoena or a court order, search warrant.
In terms of the records when you work with them, how often do you work with them?
Every day.
What do you do with the records?
So we're able to retrieve the information from our secured computer database and then send the response back to the agency that's requesting.
And I know this might sound silly, but what type of company is T-Mobile?
We're a wireless telephone carrier.
And is T-Mobile the parent company of any other wireless carriers?
We did acquire Sprint.
How long has T-Mobile been the parent company for Sprint?
April 1st, 2020 is when we acquired them.
In terms of the information that is kept by T-Mobile, do you keep phone call records?
Yes.
What would you call those?
Call detail records.
Do you keep information regarding the networks?
Yes.
Do you keep information regarding subscribers?
Yes.
What type of information is kept in a call detail record?
So call detail reports will show incoming and outgoing phone calls or text messages made or received by the cellular telephone.
Does T-Mobile keep that information as to when data is used?
Yes.
Will a data phone call or video call show up in call detail records?
No.
Does the information show for who is being called?
Yes, it will show the transaction of the outbound or inbound phone call on the call detail records.
Does T-Mobile keep the cell site information for the call that the outgoing non-T-Mobile subscriber?
No.
What's the purpose of collecting this information at T-Mobile?
Billing purposes.
Is there any consideration as to the health and optimization of the network?
So we keep what is known as timing advance records, which is solely for engineering purposes, so that they are able to check up on the network, yes.
When a phone call is made from a cellular device or handset, can you describe from the network perspective what happens?
Sure. So what happens is the phone reaches out to the tower with the strongest signal, which is not necessarily the closest tower. So for example, we can have a tower on top of the building, or we can have one down the street.
However, the one down the street might be the stronger signal and would pick up that call. At that point, it's transferred to our switch, and our switch is what records all the information that you will see on the call detail records. At that point, it's then transferred to a landline company, and it's the landline company that actually delivers the call.
So you mentioned true call data. What is that?
So true call data is for the network. It will show where the phone is connected to when it's not in use, as long as it's turned on.
Does Sprint also have a similar type of data?
Yes.
What is per call measurement data?
Correct.
Is that the same for true call, but the Sprint analogy?
Correct. That's Sprint's term.
In terms of subscriber information, what types of subscriber information is kept?
So the subscriber information, we have two types. One would be a prepay, and then the other would be a monthly account.
So the prepay, what type of information could you have?
So prepay, a customer is not required to provide their information, but they could provide a name, address, and date of birth.
On the postpaid or the billed type, what type of information do you have?
So we would have the name, the address, date of birth, social security number, and we actually do a credit check on that individual.
In terms of the individual using the specific phones or handsets, can you testify to that?
No.
How many times have you testified in court before?
Over 1,000 times.
Okay. Were you, as the records custodian for T-Mobile, provided legal process, I'm going to go through them one by one, under reference tracking number for T-Mobile 214-6318 for two phone numbers of 305-922-9533 and 954-376-9158?
Yes.
As the T-Mobile records custodian under tracking number 219-2645, where you provided records or requests and legal process for three phone numbers, 561-720-3210, 772-713-9807, and 954-376-9158.
Yes.
As the records custodian for T-Mobile under T-Mobile tracking ID 208-1851, where you submitted a request for phone number 954-248-9081.
Yes.
For T-Mobile tracking number 217-2715 for phone number 954-376-9158, where you provided a legal process to obtain the records for that issue.
Yes.
Were you also under tracking number 205-8127 asked to provide for legal process phone number records for 772-713-9807?
Yes.
Was Sprint at the time, now part of T-Mobile, under the phone numbers for 772-713-2341 and 954-371-7895 under Sprint tracking number 2018-221418, provided legal process and requested to provide records?
Yes.
Was Sprint under Sprint case number 2019-15821 asked to provide records with regards to phone number 225-529-5054?
Yes.
Prior to coming into court today, did you have the opportunity to review the records that were provided?
Yes, I did.
Are these records made at or about the time they are created by a person with knowledge?
Yes.
Are they kept in the regular course of business of Sprint and T-Mobile?
Yes, they are.
Okay. Is it in the regular practice to keep such records?
Yes.
You're at this time approaching with what's been labeled as states 000 for identification purposes and previously shown to defense. Ms. Johnson, do you recognize this USB?
Yes, I do.
How do you recognize it?
My initials and today's date are on the USB.
And does those USB fairly and accurately represent the records that were provided by T-Mobile in response to the tracking numbers that we just discussed, as well as to Sprint and the tracking numbers and case numbers they just provided?
Yes.
Here at this time, the state would offer states 000 as states 63.
Any objection?
Yes, Judge. Objection? Relevance?
Sure, why don't you come sidewalk here? Thank you. So, objection to overruled, it will be admitted. What's the next number?
63.
63 and evidence.
Permission to publish?
You may.
I'm sorry, I didn't catch you.
63.
So I'm going to start with the Sprint records. What are we looking at in this particular file, 2018-221418-6155597?
This would be the subscriber information.
And in terms of looking at this particular one, I'm going to zoom in. What is the billing name for this?
Chris Thomas.
And going to the second one, what is the billing name on this one?
The first name is Dontavius. Last name is Withers, Withers.
At the top of this screen capture, there's a BAN number. Do you know what that means?
Yes,
What is that?
that would be the account number.
Does that correlate with the other data that's been provided?
Yes.
Going to now the same Word document file name. What are we looking at in this Sprint document?
This is also subscriber information.
So you had mentioned that billing account number, that BAN number.
Correct.
If you can touch the screen in front of you, you can write on it and it will show up on the screen for the jurors. So if you could point out where the billing account number is here. Okay. And then what is the phone number that was being used by this account, or the subject number?
772-713-2341.
And is this again for that Chris Thomas billing account?
Yes.
Okay. Scrolling down to the next billing account number. Is this the other account that we just looked at the subscriber information on for Dontavius Withers?
Yes.
And what is the phone number that's associated with this particular account?
954-371-7895.
Going on to 2019-158-210-6566861. For the phone number in question on this particular record, is that labeled right here?
Yes.
And what phone number is that?
225-529-5054.
And looking at the Microsoft Excel viewer, can you explain to the ladies and gentlemen of the jury what we're looking at here?
These are the call detail records with cell site information for Sprint.
Going over to the T-Mobile records. Just for demonstrative and illustrative purposes, when you are looking, this particular one called Timing Advance LTE and UMTS _TN 772-713-9807. Then it has another underscore IMSI. What is an IMSI?
That stands for International Mobile Subscriber Identity Number, which is the number that's associated with the SIM card found in the back of the phone.
And the first, the 772-713-9807. What is that?
That would be the phone number.
Are all of these records provided by T-Mobile?
Yes.
In terms of completion codes, is that something that is reflected in these records?
Yes.
What is a completed successfully completion code?
So that means that the call went through the network successfully.
What is an abnormal completion?
An abnormal completion means the call did not go through. Perhaps the user hung up prior to the call connecting, or a dropped call.
Okay. In terms of what time frame are all of these records kept in?
We keep them in UTC time, which is Coordinated Universal Time. So depending on what time of the year it is, you would have to subtract either 4 or 5 hours from the time that you see reflected in order to arrive at East Coast time.
On October 26th of 2018, how many hours did you have to subtract?
It would be -4.
The cell site locations indicate latitude and longitude of the cell site. Is that now there's also a physical address. Is the physical address always the same as the latitude and longitude?
No.
What could the physical address sometimes show?
So that's what we refer to as an administrative address. So we use that for 911 purposes. To get the exact location of the cell tower, you would take the two coordinates, the latitude and longitude, plot it into a mapping program such as Google Earth, and that will give you the exact location.
There's nothing further of this witness, Your Honor.
Counsel, is there any cross-examination?
1 second, Your Honor. Good afternoon, ma'am.
Good afternoon.
How are you?
Good, thank you.
So, the technology that you just described for identifying locations, how is that verified by T-Mobile itself?
That you would have to ask an engineer for.
So you don't know how that's done?
How it's verified?
Yeah.
As to what tower connected to? Is that what you're asking?
Yes.
So it's done with a radio frequency, is how the towers work. It's a signal.
Okay, so but you were telling us earlier that the phone does not necessarily connect to the nearest tower.
Correct.
It connects to the tower with the strongest signal.
Correct.
So how is it that you know to approximate, how do you know how far the phone is from the actual tower?
I don't.
Is there no way to tell that?
No. Not through me.
Not through you?
Correct.
And how do you know if the tower that the phone connected to is the closest tower or the one with the stronger signal?
That would not be a question for me. You would have to ask an engineer.
How would you know whether or not a phone defaults to a stronger spectrum? If you have a tower with a strong signal and another tower with a not so strong signal, or a signal that's not as strong as the other. You with me so far?
Yes.
How would you know at what point the signal disparity is strong enough for it to default to the one that's further away as opposed to the one that's closer?
Again, that's a question for an engineer, not for me.
So you have no way of helping us understand any of this information that you just described?
Correct.
You just collect it when you're subpoenaed and you provide it.
Correct.
And you're not familiar with the technology at all?
Not the questions that you're asking, correct.
One second.
Sure.
Is it correct that the data location information, the purpose that you worked with Sprint and with T-Mobile at some point?
I'm a T-Mobile employee.
And you were a Sprint employee at some point?
No, sir.
You were somewhere else? No?
AT&T.
AT&T.
Correct.
The purpose that AT&T, and in this case now T-Mobile, collects this data location information is for billing.
Correct.
That's its only purpose.
And network engineers collect to optimize the network.
Okay. It's not used for identifying the locations of customers' phones beyond the purpose of just billing.
Correct.
Okay. Thank you.
Sure.
Thank you. Is there any redirect?
Yes, Your Honor. Ms. Johnson, counsel asked you, how do you know how something didn't happen? Is that a fair question?
Objection.
Sustained. Rephrase.
With regards to these records, are they accurate?
Objection.
What's the objection?
Lack of foundation, Chief.
Why don't you come sideward? The objection was sustained. Rephrase.
Okay. So, Ms. Johnson, with regards to the records, does the T-Mobile keep any record of something that doesn't happen?
No.
What is contained in the records that have been provided?
Calls and text messages that have happened.
Is this from the network's perspective?
Yes.
Nothing further, Your Honor.
Is this witness excused?
Yes, Your Honor.
Thank you. You may step down. You're excused.
Thank you, Judge.
ma'am. Who is your next witness?
Jonathan Zeller.
Jonathan Zeller, please. Good afternoon.
Good afternoon, sir.
Are you Jonathan Zeller?
I am, sir.
Welcome. Come on up here, sir. That's our witness stand. When you get there, you put your things down, you raise your right hand, be sworn.
Do you solemnly swear or affirm the testimony you shall give in this case shall be the truth, the whole truth, and nothing but the truth?
I do.
Please state your full legal name for the record.
Jonathan Zeller. It's Z-E-L-L-E.
Spell your first name as well, sir.
Jonathan.
Thank you.
And that microphone will just up or down, but not back up.
Yes, sir.
Counsel, if you're ready, you may proceed.
Good afternoon.
I'm sorry, can we approach very
May I approach your next?
Thank you. Anything else, Council?
No, Judge.
Bradley, if you're ready, you may proceed.
Okay. Detective, how are you today?
I'm good, thank you.
Good. Where do you work?
I work with the Miramar Police Department
How long have you worked for the Miramar Police Department?
for 23 years.
What do you do for the Miramar Police Department?
I'm a detective in the homicide unit
And how long have you been in the homicide unit?
since 2009.
Prior to going into the homicide unit, what other hats have you worn for the Miramar Police Department?
Several. One in particular is a forensic, digital forensic examiner.
Okay. What is a digital forensic examiner?
So what I do is we'll stick with the cell phones or cellular phones or devices of that nature. I do the extraction and the analysis for it.
And when you're doing an extraction, can you explain to the ladies and gentlemen of the jury what types of software or tools you use to do an extraction on a cellular telephone?
Okay, so what we use is a software and hardware from a company called Celebrate, and this is specific for conducting extractions of cellular devices.
And approximately how many different trainings have you taken in the use of Celebrate systems?
I've taken a few. Each of them consisted of 40 hours of class training and exercises, and obviously the exam as well.
What about, have you taken training with the CAST team of the FBI?
I have.
Have you taken, you said you also do analysis of the cellular forensics or digital forensics. What do you mean by that?
So, depending on what type of case it is, I will actually do the extraction and I'll also do the examination of it, the analysis for it, and go through it and look for items that potentially could be considered evidence.
And in terms of to do the analysis part, what information do you need?
I need to know what the case.
In this case that we're here on today, Miramar Police Department Investigation 18-10-06269, were you the lead detective?
I was not.
What was your role in this case?
Doing the analysis or the extraction of the device.
Did you do any analysis of the device?
I did not.
In terms of the extraction of the device, were you provided an iPhone with the phone number attached to it of 772-713-9807?
Yes, yes.
Prior to coming into court today, did you have the opportunity to review the digital copy of that extraction?
I did.
Okay. I'm showing defense counsel what's the darkest states triple P for identification purposes, showing the witness. Detective Zeller, do you recognize this thumb drive?
I did.
How do you recognize this?
My initials and my ID number on the jump drive.
What is that thumb drive contain?
This is the generated report of the generated report of the cellular device that was extracted.
And is that in the same or substantially the same condition as when you performed that extraction?
Yes.
Here at this time, the state would request to move states triple P in as state 64.
Objection.
Yes, sir. Name?
Sure. Objection overruled. Let it be admitted.
4.
What's the next number?
64.
Thank you.
So Detective Zeller, can you explain to the ladies and gentlemen of the jury what an extraction does?
So the extraction consists or is done in order to obtain whatever is on that phone and to put it in a legible or readable report that's easy for someone to look at. And some of the things that you will get also by doing that, you may get items that have been deleted, so on and so forth. And that's why we do those types of extractions.
Nothing further from this witness, Your Honor?
Any cross-examination?
Yes, just briefly. How are you, sir?
Good news, sir.
You said you did a phone dump here of a particular unit that the state referred to.
That's correct.
And you have not analyzed it?
No.
You don't know if there's any relevant evidence on it at all?
That's correct.
Okay. And you don't know who it belongs to, do you?
I do know who it belongs to. Obviously, I'm in the office. I know who it belongs to, but as far as the contents of it, I don't know.
You don't know. You don't know who uses it.
I do not.
You don't know who it's registered to.
I do not.
Okay. One second. And as to any contents of that phone, you don't know if they're texts, who authored them.
Once again, I don't know the contents of it.
Okay. Okay, Your Honor, we'd like to come sidebar if you sure.
Thank you. Let the record reflect the jury stepped out. Counsel remain along with the defendant, Mr. Demons. Demons, you need a restroom break? Need a restroom break? Nope. All right. Thank you. And what is it you all want to share with the cases?
Okay, Your Honor, and I can hand them up as I discussed them. I don't think I left one with the court. The one that I referred to first is RLG versus State, 322 Southern 3rd, 721, a third DCA case.